Judges are being asked to overturn an 87-year-old rule in a move which could allow more rape allegations to reach court. Scotland's top law officer is seeking the change after 2 sexual offence trials last year ended in acquittals. The ruling dates back to a case which took place in Glasgow in 1936. Our Home Affairs correspondent David Cowan reports.
The might of Glasgow's police force is in the annual church parade to the cathedral. 2,000 men under their commander, Chief Constable Silito.
The police force which paraded through Glasgow in 1936 dealt with a case which has influenced Scots law for decades. In this tenement close, a woman had been indecently assaulted. She said a man called Henry Morton was responsible. Henry Morton went on trial here at Glasgow's Old Sheriff Court. He was found guilty, but the woman was the only person who identified him as her attacker, and a year later the conviction was quashed on appeal. The Morton appeal in the 1930s set limits on what can be done with evidence in sexual offence cases. They've been in place ever since. Fast forward to 2024. Scotland's top law officer has spoken often of her desire to improve the system for victims.
We need to resolve these issues in and around sexual crime. They have a profound impact on the victims. They ruin lives. We've got to do something about it. We've got to have a better system.
At the heart of today's argument was corroboration, a unique cornerstone of Scots law.
Basically what it means is you need 2 independent pieces of evidence for all of the essential facts of the case. So historically that's meant that you couldn't be convicted on the evidence of a single witness, no matter how honest or plausible or credible they might seem.
The Lord Advocate wants to overturn the ruling from the 1930s because it was heard by 7 judges. The High Court witnessed the historic sight of 9 judges filing out to hear the arguments.
And it's strongly in the interest of justice and the public interest that if the law is taking a wrong turn, then that is a matter of profound importance that requires to be remedied.
She wants statements made by an alleged victim shortly after an alleged offence to be used to corroborate evidence that the crime took place and the accused was responsible. At present, such statements are generally regarded as hearsay and inadmissible.
I think it would be a very significant change. This would effectively be the end of corroboration as we've known it for almost 100 years in Scotland. That is a huge intervention in the justice system. It would mean that we could rely on the evidence of really a single witness, potentially, to corroborate far more than they can currently do under the current law.
Senior defence lawyers agree changes are required, but they say the Lord Advocate wants to go too far. If she wins, it would mean more rape cases would reach court, but juries will still have to decide if they've been proved beyond reasonable doubt. The 9 judges will issue their decision at a later date. David Cowan, BBC News.
Well, I'm joined now by the lawyer, Thomas Leonard-Ross KC, and also by Sandy Brindley from Rape Crisis Scotland as well. Good evening to you both, and thanks for joining us. Thomas, to you first. At the heart of this issue, as we've just heard, is corroboration. Campaigners say that currently there's an ongoing barrier to justice. What are your thoughts on that?
Well, there are 2 sides to the argument, of course. I think the verdict will go in the court the way everybody expects, and it will be found that things said by the victim at the time can provide corroboration. And that will give hundreds, if not thousands, of people who are denied access to court, access as a result of this decision. But there's a danger as well, because clearly the rule has existed for 90 years to serve a purpose, and the purpose is that it provides some protection against somebody suffering the consequences of a false complaint.
OK, well, let's bring Sandy Brindley in and get her thoughts on that. Sandy, what do you believe that this could mean for alleged victims, and do you accept that there could be a concern about miscarriage of justice here?
Yeah, I really would commend the Lord Advocate for her commitment to trying to address what clearly is a justice gap in Scotland in relation to sexual crime. The vast majority of reported rapes never make it near court, and the reason for that is most often corroboration. I think this, if the decision goes the way that Tommy thinks it will, I think it could make a really significant difference for complainers. I mean, it would make a difference to removing a barrier to cases getting to court, but it wouldn't necessarily have an impact on convictions, because the prosecution still have to prove the case beyond reasonable doubt, and that is the ultimate safeguard against Tommy's concerns there about any possible miscarriage of justice for the accused.
OK. Thomas, would you like to respond to that? And would it be the case perhaps that more cases would go to court, but it wouldn't necessarily alter the conviction rate?
Yeah, Sandy's right, of course, but it's no joke being in bail for 3 years charged with rape. You know, you could be in custody for that time. You could be thrown out of university. There's a campaign behind that. You could be denied access to your kids. So all of those things could happen as a result of the case being taken up in the first place. And you know, of course, you would be relieved if you were acquitted at the end of it. But you can't rewind and give you all those things back if you've been lying in remand for 3 years waiting for the case to come to trial.
Sandy, do you believe that it would actually alter the conviction rate?
I don't know that it would alter the proportion of cases that are prosecuted result in a conviction. It may have a marginal impact, but I think what we will see is more prosecutions, but not necessarily a huge increase in convictions. The test is so high beyond reasonable doubt for juries to convict. And I think there is ongoing work there. But beyond this ruling, which is really significant, I think there's ongoing work, as Tommy highlights, the delays in cases getting to court are dreadful for accused people and also really dreadful for complainants to have this hanging over them for 3 years. But also, I think we need to look at how do we better prepare complainers to give their evidence in court? How do we make sure that juries are making decisions based on the evidence and not maybe common assumptions about rape? So I think there's so many other things that we need to consider in addition to what this really would be a seismic change if this judgment does go the way that we think it might be. But it's not the end of the story. There are still so many other factors to address. Some of the causes really of the very low conviction rate they have in Scotland and the justice gap that women who've been raped experience in Scotland.
Sandy, if it didn't alter the conviction rate much, what would be the argument for doing it then?
I think there's an argument really powerfully being made by a number of survivors, particularly survivors of child sexual abuse, which can be very difficult to prosecute unless you've got more than one survivor speaking out against the same perpetrator when their stories can often corroborate each other. If you don't have that, it's almost impossible to mount what's known as a historic prosecution, because how do you prove penetration without forensic evidence if there isn't any? And there's a group called Speak Out Survivors that have really articulated clearly the injustice they feel that if they had been sexually abused across the border in England, their case could have got into court, whereas in Scotland it can. And I think for those women it really feels like an injustice and they want their day in court.
Thomas, Dorothy Bean, Scotland's Lord Advocate, said today, we just heard it there in David Cowan's report, that we need to resolve these issues. In her words, they ruin lives. We've got to have a better system, were her words. Do you agree that the system needs to change?
Yeah, I mean, if I was being judged by how many people were convicted, which she is, then I would be making that argument as well. But you know, there is a concern that when this rule comes in, and I've no doubt that it will come in, that it will apply to the single victim cases that do result in a lower rate of conviction. And for the first time, we'll have a system where it will be easier to prove a rape than it will be to prove a false complaint of rape. And Sandy knows, in a 10-minute search in Google, you can identify many people who have been convicted of Scotland of making false complaints. And my concern is that although I'm prepared to accept that the vast majority of people are honest, it's not difficult to find cases, and the people who do it give an explanation to the court through the lawyers why they do it. And alcohol is often a feature. People say that I made a false complaint at the time because I was upset and too much to drink. And that's exactly the type of material that will now be used to corroborate, namely that the police went out and spoke to the person and she made a complaint under the influence of drink, you know. And so that's my concern. I'm prepared to accept that probably it's outweighed by the number of people who are denied access to court because of it, but there is a concern about it.
Okay, let me get you to respond to that. Sandy, do you believe that false complaints are significant?
No, I think Tommy's just incorrect there when he says there are many cases of false allegations. I think there are some, but they are rare. And even if this judgment does go the way that we are talking about tonight, you're not going to see a rape conviction on only a complainer's evidence. There will still be supporting evidence. I think this is like a little bit scaremongering here about what might happen. As I said, the prosecution still need to prove the case beyond reasonable doubt. That is a very, very high bar for the jury. And we know that juries can be particularly reluctant to convict in cases such as this, and that this spectre of false allegations being common, it really does not help us, I think, in terms of trying to move to a discussion on rape cases based on fact and not on myth.
Okay, we will have to leave it there, but we're grateful to both of you for your time tonight. Tommy Ross, KC, and Sandy Brinley of Rape Crisis, thank you both very much indeed. And if you have been affected by sexual abuse or violence, details of help and supports available at bbc.co.uk/actionline, or you can call for free at any time. You can hear recorded information on